So what that means is that, of course, we are going to go over your rights and the charges they have you here for, but also we're going to go over the bond amount. Bond, of course, being the amount of money that you need to post with the court of the county before they let you out of jail. Once you pay, you can go, but you do have to come back for court at a later date and time, because if you don't come back for court, they'll issue another warrant for your arrest and kind of start all over again. So do make sure you make your court appearances. By posting your bonds, you have not completely taken care of the cases. Sometimes bonds are in the form of a surety bond, sometimes in the form of a cash bond, and sometimes no bond at all, but we'll go over that. In certain cases, there might even be personal bonds, but again, those are all different forms of bonds. You can post the bonds in cash in full if you have that kind of money. Most people don't, so they go through a bondsman, but if you can afford to put the money up in full, in cash, on long run, you actually save a little bit of money, because then when you come back to court, you get to file that money toward the fine. If you're found guilty, or if you're found not guilty, the case dismissed, you're going to get all that cash back. But again, it's only when you post money in full in cash. Other than that, though, each of you here absolutely still have constitutional rights. You certainly have the right to remain silent. You do not have to talk to police at all, because anything you say can and probably will be used against you later on. So again, you still want to be careful what you say. And if you start to make a statement to police, and it's kind of unusual to see them want to come down here and interview you after that, but if they could, and if they do come down here to talk to you again, you can talk to them if you want to, although I just warned you about your right to remain silent. But if you do make a statement, you can always stop at any time. You don't have to continue to talk. You have the right to speak with an attorney, have an attorney present during questioning, and have the attorney represent you in court and at trial. And if you cannot afford to hire your own attorney, Denton County will appoint and pay for an attorney for you, or if it's a warrant from a different county, that county would appoint and pay for an attorney for you, so long as you're truly indigent. Indigent means don't have a job, source of income, family, friends. You don't have any way by which you think that you can afford to pay for your attorney either now, or even if you bond out. If you really do not have the financial resources, if you indicate that on this form, we'll start our process to get you a court-appointed attorney. Indigency is a pretty low standard, meaning that you certainly don't have any money, don't any funds, any way that you can do that. But we'll start our process. Normally we have you fill out a sworn affidavit. Just make sure that you fill it out completely and truthfully, showing you are in fact to afford an attorney. We're going to process that information. If Denton County deems that you're indigent based on the information you provide, Denton County will appoint or assign you a court-appointed attorney. Although you normally won't talk to a court-appointed attorney for another 2 or 3 days after date of appointment. So might be the end of this week before you're actually talking to an attorney, possibly even the beginning of next if you don't bond out. Even if you do bond out, you can contact that attorney once you get out. And if it's a warrant from a different county, we'll tell that county that you're asking for a court-appointed attorney so they can start their process. If you're here for a felony grade offense, you're unable to post your bond after a reasonable period of time, you can also ask the court to release you without posting bond at an examining trial. Again, that's really kind of a legal process that normally starts, that applies only to felonies, only when you'll be able to post your bond, and only when there's not been an indictment returned against you first. Last, but certainly most importantly, you certainly still have the right to a trial by judge or jury. Just because you're charged and arrested doesn't mean you're guilty. You do have a right to a trial, but you need to post your bond in order to get out of jail prior to going to trial. So let me start off with William Gasway. Mr. Gasway, come on up. And Mr. Gasway, this is just where their bondsman, where the court is holding your bond to be insufficient. So it looks like you had already posted bond, but now the court's holding your bond to be insufficient. That typically happens when you're charged with another charge after being released, or where you fail to abide by some condition of bond, like you didn't get your ignition interlock installed or you didn't keep it up. So for that reason, you have a new bond. There's some good news. Have a new bond at $25,000. Let me make sure that's unusual. See them do that. I'll be darned. You have a preset bond at $25,000. So it is bondable. It's on F20. That's probably why it's an old case. F20-1123367. So it's bondable again, but a bondsman probably range about $2,500 to $3,000 to get you out, but it is bondable. If you do get out, make sure that you have your ignition interlock system installed, make sure it's in good working condition, and check in with pretrial services. So let me get your signature on that form in front of you. Just saying, we talked about your rights, your charge, and your bond. You're not admitting guilt. Not saying you agree with it. Couldn't if you wanted to. And then do you have your own attorney, Mr. Gasway?
Yes, sir.
Initials in that top box saying you're not asking for a court-appointed attorney. All right. Talk to your attorney about this and go ahead and try to get your bond posted, okay?
Thank you.
Corey McAllister. Mr. McAllister, one charge of burglary habitation. It is not a new case. It's an old case, one in which your bonds, your probation is being held, where they're revoking your probation. That's probably because of the two additional newer charges for, looks like, aggravated robbery and burglary habitation. So you're out on probation for this burglary habitation, so that kicks this one back into a no bond status. It doesn't mean you can't get bond set, but you'd have to get the judge of that court, which is Judge McFarland, to set your bond for you. So do you have an attorney on this case, Mr. McAllister?
I have a court appointed.
Okay, let's get your initials in that bottom box saying you need your court-appointed attorney to contact you. We'll notify them so they can come talk to you, and then they can file a motion to try to get a bond set for you. And then your signature on that line, right by that, just saying you understand rights, charge, and bond, not saying you agree with it. So, yeah, those are Denton PD cases. Okay, thanks. Gary Whiteside. Mr. Whiteside, this is a no bond status. It doesn't mean you can't get bond set, but because it's out of a felony court, a 362nd District Court, again, your attorney's going to have to contact Judge McFarland and try to bond set for you. Warrant S-17-2022, out of the 362nd, again, not a new case, just a probation violation on DWI. So let me get your signature on that line saying we talked about your rights, your charge, and your bond. And you can also talk to your attorney and see if they can run this time concurrently. It'd be probably better if you just get all these kind of wrapped up into one big bundle and take care of them at the same time. Yeah. And then initials in the bottom box if you still need court-appointed counsel.
No, sir, I'm good. Thank you.
You have your own attorney?
Yes, sir.
One that you hired?
Yeah.
Okay, then let me get put your initials in the top box there.
I did.
Oh, you did? Okay, fantastic. At least he knows what we're doing. Thanks. Ethan Edwards. Mr. Edwards, let's see, one charge terroristic threat of a family household member. That is a warrant that was pending out of JP Precinct 1, but it's actually been filed now, and County Criminal Court Number 2, Judge Peel's Court, warrant CR 2021-04934-B. So it is a bond at $2,500 on that charge, but it is bondable. Charge of expired drivers, expired registration or plates at $202 in bond, and violate promise to appear at $367. But on those top two, I've worked out something with the JPs to see if we can get you credit for those so you can try to post your bond on the other case. So again, without saying you agree with it or admit guilt, let me get your signature on that form saying you understand those three cases and that you could post bond, that you could go to trial on all three of them if you posted bond. Or even if you don't. And then do you think that you can afford to hire your own attorney and post your bond?
Yes, sir.
Initials in that top box saying you are not claimed to be indigent yet. And again, as I said, I've worked out a deal with the county JP courts, and that is if you want to enter a plea of no contest on these two old cases, these came back from 2014. Had a fine or bond at $202 on expired license plates and a fine or bond at $367. I'm going to recommend to those courts, if you enter a plea of no contest, to give you full jail credit for both cases. So if you want to ask for full credit, understanding you're entering a plea of no contest and waiving trial, let me get your signature on each one of those lines. And then we will clear those two off the back of your book, and you'll still need to post bond on the $2,500 one, okay?
Sir.
All right. Well, Merry Christmas on that.
Thank you.
And Thomas Winkleblack. Mr. Winkleblack, let's see. Well, good news is I'm not adding a new charge for me in the state of Texas. Bad news is you posted bond on the Denton County case, and we're going to try to get you on your way to the state of Oklahoma, Grady County. Where's Grady County?
Up by Oklahoma City, sir.
Well, they miss you. They'd love to have you come talk to them again. So they apparently have confirmed on a warrant out of Grady County, Oklahoma, on the charge of concealed stolen property.
Yes,
So on that charge, they demand you return to the state of Oklahoma to either stand trial or complete your sentence on that charge.
Oh, When you say stand trial, does that mean I'll get a bond probably, or?
You can once you're in that state. In fact, you could even theoretically get a bond set while you're still here, but here's the problem. You couldn't post a bond from here. You'd have to be in that state before that happens.
All right.
So right now, though, you can fight extradition and demand that they not return you to the state without appearing before one of our district courts for what we call an extradition hearing. If you do that, it could take up to 90 days before that could get set up. And at that extradition hearing, you would have the right to ask for court-appointed paid-for attorney or hire your own on the extradition. But the only issues you could be heard here in Denton County or anywhere in the state of Texas would be on whether or not you are, in fact, Thomas Ray Winkleblack, born on January the 18th of 2000. Well, happy birthday, dude.
Thank you, sir.
Yeah, one day late, but hey. And the year 2000, that makes me feel very old. Thank you very much.
The charge I have here, my attorney, I'm trying to get an attorney for it because the only reason we got the charge here is me and my wife told the detective that we didn't want to talk to him. So I guess the state picked it up, but she was wanting to figure out how she needs to go about that because nothing happened.
She will have to contact the Denton County District Attorney's Office, but I will tell you this, there's no guarantee that they will drop it. It's very hard for them to prosecute a case where the alleged victim is not asking for it, but we will try to, she can contact the district attorney's office.
Yes, sir.
In the meantime, just keep in touch, make sure that you put that your address that you put on your bond is a good address where you get your notifications, because they'll send you court. And so, yeah, you can work all that out in the future. Okay.
Yes, sir.
And you can also come back and ask for a court-appointed attorney on those as well.
Yes, sir. I think my bond was posted for that charge, is a $2,500 bond.
The bond is at $2,500. And I thought you had, it looks like you do, it looks like you had a bondsman that's posted the bond for you.
Yeah, it was supposed to be posted. That's what I was making
Okay.
sure.
So yeah, we're just holding on this one charge out of Oklahoma. So again, you can challenge the legal sufficiency of the documents, saying that in demand a governor's warrant of extradition or governor's warrant, or you can challenge they don't have the right person, but those are really the only things that you can challenge. And if you did that, it would add probably 30 to 90 days worth of time here in Denton County. Or you can waive extradition, agree to have us notify that county to come pick you up. We would give them, normally we give them only 10 days to come pick you up. Texas is a 90-day state, but we do, if they can't come pick you up in 10 days, we typically release you and then they'll reactivate their bond. But this will speed the process up. So if you want to waive that extradition hearing, then you could be returned to Oklahoma and then post bond there.
All right. So they have 10 days after I agree to this?
We will notify them that they have a 10-day hold, and they can contact us and ask for more time, but there would have to be some extraordinary basis for them to do that.
Yes, sir. Then I want to waive my right for extradition.
Okay, then let me get your signature on 2 sheets. The first one saying I told you about your right to an extradition hearing, your right to court-appointed counsel, your right to challenge the legal sufficiency of the documents.
This is agreeing to go.
And then the second one is a formal waiver. This is what we will send to Oklahoma to tell them to come pick you up and start their 10-day period of time.
And they'll be notified today since I signed it today?
We will notify them today. I don't know if it's 10 days, I think starts the following day. So it starts tomorrow, I believe.
All right.
Okay.
Yes, sir.
All right. We'll get you a copy of that so you'll have something to go on.
Yes, sir.
All right. Thank you.
All right, gentlemen, same way we came in, we're going straight up here, all right?
Oh, can you hold on one second? I need to, give him his paperwork before he leaves.
Oh,
So this was, let me print it out and get.
Hello.
Thank you.
All right, let's go.
Good luck, gentlemen.
Thank you.
All right. Thank you, Judge.
Thank you. Thanks, Angela. And yeah, you can stay here and work on